everyone. This is Kathleen Taylor, and I'm with the Nevada Women's Business Center. And today, I'd like to first of all thank everyone for tuning in on our YouTube channel. I am so excited today to have a special guest here, Mr. Jonathan Fountain, and he's going to give his expertise on patents, copyrights, and trademarks. So, Jonathan, thank you so much for being here today. We really appreciate it.
You bet,
Thank
Kathleen.
you.
Thanks for the wonderful introduction, and we're very happy to be here.
Oh yes, definitely. And it's such a treat given that with our client base, intellectual property, we always have questions about that. So it's great to have you on to, give us some advice,
Sure.
from a legal perspective about that. And I'd like to share with our audience some things about you and you're definitely accomplished individual in the field of law. So I'd like to share some background with you about Jonathan. And Jonathan is a practicing attorney at Lewis Roca Rothgerber Christie, and he has a plethora of experience in the firm's intellectual property and commercial litigation practice groups. Also, he litigates complex domestic and international trademark, rights of publicity, copyright, trade secret, patent, and business disputes in federal and state courts. It's quite impressive. Also, prior to joining the firm, Jonathan was an associate in the commercial litigation practice group at the international law firm of Miller, Canefield, Paddock, and Stone in Detroit, Michigan. So it's my pleasure to have you here on board with us, Jonathan. So uh, at the Nevada Women's Business Center, our clients are primarily either startup entrepreneurs or people that are established business owners. And as I was mentioning earlier, they always have questions about intellectual property. So why don't we kind of start with the basics of intellectual property one-on-one, so to speak. And I'll hand it over to you, and then we can kind of like drill down a little bit
Sure.
more
Sure.
about trademarks, patents, and copyrights.
Okay, well, I'll start with the easiest first, which is copyrights. And copyright law is a body of federal law, laws enacted by U.S. Congress. And copyright law protects expression. And that means the words of a book, the words of a poem, song lyrics. It's going to mean paint on a painting. It's going to be any type of artistic or creative expression
Okay.
that someone puts into a tangible form. And it could even extend to sculpture, for
Oh.
example.
Interesting.
And it could be a wall covering on a casino. It could be an artistic feature of an architectural element. It can even extend to the design, the physical design of a building.
Oh, really?
Yes, so copyright is the body of law that protects expression, how we write, what we say, what we paint, what we draw.
Okay.
Music also.
Uh-huh.
Don't want to forget music and motion pictures and video. And in fact, this presentation would probably fall under copyright law, this video that we're doing right now. And so anything that's going to involve expression is going to be, we're going to put that in the can that we'll call copyright law.
Okay. Well, in reference to like expression and painting images, I always get this question from entrepreneurs or our clients, and that is, can they copyright a logo or patent a logo for their company's logo? What's your thought about that?
Well, then we're talking about two different types of intellectual property when we're talking about a logo and patentability. A logo would fall under trademark law.
Oh, okay.
And could also be copyrighted depending on the artistic elements of the logo. But let me try and distinguish what a copyright is
Thank you for that.
from, what trademarks are from copyrights.
Okay.
I misspoke for a second. What a trademark is it's could be a logo, could also be a word. And that word is going to embody the association that consumers make between that word and a particular source of products.
Okay.
For example, when I see the word Nike, I know whose shoes those are. I know who makes those shoes. So the word Nike would be an example of a word that is a trademark. Now when I see the famous Nike swoosh, that's a symbol or a logo. And I know that that is also an indicator of Nike as a source of product. Now if Nike hires an artist to make a really cool version of their swoosh, we could protect that cool version of the swoosh with copyright law because that's expression.
Ah, yes. Interesting. Please continue. This is fascinating.
Sure. So a logo or a trademark, the whole purpose of that is to connect a particular source of goods or services, a particular business, with that mark or that name, so that when a consumer sees it, they recognize it.
Okay.
For example, when you see Campbell's soup on the shelf, the distinctive red and white can, that's going to be a subset of trademark we call trade dress. But the whole idea is this association you make in your mind between that word or that logo and a particular source of products. So for business owners, one of the first things they want to do when they form a business is they want to figure out what they're going to call it.
Right.
And so this is a challenge that we face all the time. When someone actually starts to use a particular trademark in the course of selling their goods and services, they acquire common law rights in that name.
Yes.
And once they do that, if someone later comes along, they're going to be a junior user, and they're not going to have rights in that name. And the senior user, the one who uses it first, may be able to stop the junior user from using the same name or a name that's confusingly similar.
Is that called infringement?
Yeah, that's
Okay.
exactly what I'm getting at. But for a business owner or someone wanting to start a business, you can't just come up with any old name. It's a really good idea to hire a lawyer and do a trademark search to make sure that you are not going to use a name that someone else has superior rights in.
Right.
And so with trademarks, as I mentioned, once you start using that trademark in commerce, you're going to acquire rights in it, and at some point you may apply to the federal government for a federal trademark registration that would give you the exclusive right to use that mark in the entire United States for the particular goods and services that you're selling.
Right.
And so once you have a federal trademark registration, that gives you the ability to exclude others from the field. And if someone comes along and they start using your trademark or a confusingly similar mark, they don't have to be identical.
Oh, okay.
And that's a common misperception, is that you have to have identity in the terms of uses to have infringement, but that's not the case. If I started selling Apple's computers with an S on the end, that would be an infringement of the Apple trademark.
Question in reference to like marketing, marketing content.
Sure.
If someone's tagline is similar to someone else's tagline, and that person has that content trademarked or copyrighted.
We'll say trademark.
Thank you. Would that be infringement if they have a similar tagline to someone else?
In the field of trademarks, when we talk about infringement, the goal of trademark law is to prevent consumers from being confused as to the source of goods or services.
Okay.
So they want to make sure that if I'm selling shoes and you're selling shoes, that consumers don't get confused between you and I.
Okay.
If we use a trademark that's very similar. So, I'm trying to remember what your question was.
Oh yeah, that's okay. If let's say that there's a company, and I'm trying to think of a tagline that's very common for a company, and another company has a similar type of tagline. Would that be considered infringement on that trademark?
It's going to depend on how similar they are and if they're creating the same overall impression with consumers.
Okay.
If a court looks at this, and a court would apply several factors to determine if there is a likelihood of confusion, and if the court determines there is a likelihood of confusion, then that would be infringement.
Okay, I understand. So it's about perception of the consumer base.
That's right, because we're trying to protect consumers from being confused.
Okay.
So the court's going to look at things like how similar are the taglines, what do they look like, what do they sound like, how do they appear in the context in which they're used in the actual marketplace.
Okay. Would you, so from a business owner's perspective, would you advise someone to get any and everything, trademark, copyright for it, or a patent for it, or just be very discerning, or it depends upon the purpose? What would be your advice for that?
Well, first, before selecting a name for your business or a tagline, you should talk to a lawyer, and they'll do a search. They'll do a comprehensive search to figure out if anyone else is using that tagline or something confusingly similar to that tagline, and they'll give you an assessment as to the degree of risk involved in using it. It could be high, it could be low. So the first thing is consult with a lawyer and make sure that you're in the clear to use a particular tagline.
Yes. When entrepreneurs are starting up, or even if there are established business owners, would you say that it's best to have legal counsel in the beginning, and look at that as an investment versus going on your own, not having legal counsel to do the due diligence and doing the research to make sure that I'm in the clear to use this logo, I'm in the clear to use this tagline, or this likeliness of something, and doing that on your own instead of hiring an expert or consulting with an expert in that field, and making that initial investment and bringing you guys on, versus having to pay even more so down the line, and when you find yourself in court because you found that you are infringing upon someone else's intellectual property. So what would be your advice in integrating counsel, during the process of someone opening their business?
Well, I'd first like to distinguish between two different legal aspects to intellectual property.
Okay.
On the one side is what's called prosecution.
Okay.
And on the other side is what we call enforcement.
Ah.
And on the prosecution side, that's going to be when let's say you're a new business and you want to reserve for yourself a trademark.
Okay.
You're going to file an application with the United States Patent and Trademark Office. And that process is going to take a period of time, let's say 6 to 18 months or so. And during that process, the Patent and Trademark Office may have legal questions that they want you to answer. Your lawyers answer those questions. And ideally, at the end of the process, you are issued a trademark registration certificate.
Okay.
We're going to call that procedure that you go through to actually obtain intellectual property rights prosecution.
Okay.
Now, on the other hand, if you have a trademark and someone infringes it and you need to sue them, we're going to call that enforcement.
Okay.
And so for the different types of intellectual property, copyright, trademark, and patent, there's a prosecution side where you go out and obtain your rights, and there's an enforcement side where you enforce those rights. Now back to your question. You could spend a few $1,000s today to have a lawyer do a search and get you a trademark and go through that prosecution phase so that you're in the clear, or you could be the defendant in a trademark infringement lawsuit and spend hundreds of thousands of dollars defending yourself. So I definitely recommend that even if you're just starting out, that you make a small investment in doing things the right way up front, contacting a lawyer rather than trying to sort of navigate the minefield of copyright and trademark law by yourself and end up on the wrong side of a very expensive infringement lawsuit.
Excellent. Now, I'm the type of person where the more I hear something, the more I get it, so to speak.
Sure.
So do you mind at all, Jonathan, if you could kind of, and without me interrupting, of course, going through like the 3 main points or so of each one: trademark, copyright, and a patent, please?
Sure. So I started out earlier talking about copyrights, and I said copyrights
Uh-huh.
protect expression. And I talked about song lyrics and words on paper and paintings and sculptures and those types of things. And then I talked about trademarks being the body of law that protects the association in a consumer's mind with a word or a mark in a particular source of goods or services. And so I'll move on and I'll talk just briefly about patents. And patents are the body of law that protects ideas and protects useful inventions and articles. It's going to patents are going to protect new innovations in technology. And for something to be patentable, it has to first be useful. It has to be something that provides some type of utility, a means of performing a task or a function. It has to have a real useful purpose.
Okay.
It also has to be novel, which means it has to be new, something that someone else hasn't previously invented. And it can't be something that's particularly obvious, like the wheel probably would not be patentable at this stage of development of technology. So generally speaking, copyrights protect expression, trademarks protect that consumer association with a particular seller of goods or services, and patents are going to protect ideas behind useful products. And when I say ideas, that's the actual the actual technology, the process, the means of creating this invention. It's going to be the computer technology, it's going to be the hard engineering, it's going to be the difficult mathematics, it's going to be the chemical combinations that actually result in this useful article or product.
Okay. I find this fascinating, and how would, and this may get a little bit into business law, so to speak. How would one draw up a contract that incorporates, patent, copyright, trademark protection in the terms of agreement, or that isn't typically a part of a contract? Or what type of document would be drawn up, if there is one, that would say, okay, I'm going into a partnership agreement with you. I have this intellectual property, this software that I'm creating, and it's my intellectual property. How do you integrate that into the terms of agreement within a contract that once this partnership is dissolved, that this remains mine?
Well, I think you say it just like that.
Okay.
In terms of contracts dealing with intellectual property, we usually have assignments or licenses.
Okay.
And an assignment is going to be a transfer of ownership. It's like it's a fancy word for selling something.
Okay.
So I may sell my individual copyrights to a company,
Okay.
and then the company will own them. And an assignment is a permanent transfer
Okay.
of intellectual property rights. A license would be something that is not permanent, and sometimes they're irrevocable, sometimes they're revocable. But licenses are common in intellectual property agreements. I may license to you the right to perform my play
Okay.
that I have written, and I may license it to you for a certain period of time. It can only be performed in a certain manner, and after a certain date your license terminates and those rights revert back to me.
Okay.
And for the privilege of being able to perform my play, you may pay me a license fee.
Okay.
And so those are a couple of examples of how intellectual property might work in a contract. A person who's an independent contractor, let's say they're a software developer, you might want to hire them, and you might want to have a written agreement that covers your relationship in it, and if you want to own the copyrights in the software that the software developer writes, then you would need to specify that in your contract.
Okay.
And that's another example of a contract that might contain language concerning the ownership of intellectual property. In this case, copyrights in software.
Okay. Speaking of expression, verbal expression, is there some type of infringement if let's say that in the music industry, and they're cover bands, and they you have this band that sings, for example, Journey. Journey's one of my favorite groups, and this phenomenal cover band is singing all of Journey's songs for selling tickets and generating revenue, and because of the freedom of speech, so to speak, amendment going on here, is this band infringing upon the content of the songs of Journey, or that's kind of like the gray area that could be, that's maybe involved in intellectual property?
I don't have a precise answer for you because I haven't researched this question lately.
Okay.
However, my gut reaction to your question would be that a band covering a Journey song, if they are doing so publicly and they're doing it for money, and if their rendition is substantially similar to a performance by Journey, then that might be an infringement.
Okay, interesting. And you yourself, of your very talented professional, excellent portfolio of work in the law industry, and as a lawyer, an attorney, you have the potential, possibly, of opening your own law firm, right? So possibly, just hypothetically.
It's always an option.
Okay, always an option. So if someone wants to embark upon opening up their own law firm, so to speak, what advice would you give them? I'm just kind of like giving a little like bonus footage, so to speak, for those of you that are interested in the field of law from an entrepreneur perspective. What would be some advice that you would give them?
Well, I've never opened my own law firm, but if I were going to, first and foremost, I'd want to have clients.
Sure.
That would want to patronize my new law firm. I would want to make sure that I'm not infringing someone else's mark when I name my law firm. I probably wouldn't, because I'd probably name it after myself.
Okay.
I would certainly want to have malpractice insurance.
Oh, very good.
And I would certainly want to consult with the State Bar of Nevada in this case about specific rules for attorney advertising. And there are also rules governing who can financially participate in a law firm. So I'd be very careful to review the rules of professional conduct in that regard.
Sure.
And I would want to engage a PR or an advertising agency to help me launch my law firm, to come up with some pretty consistent, professional-looking advertisements and internet content for my law firm.
Very good. Well, that was some really good bonus footage, and and then, like you said, it's just an option. But I just wanted to kind of get your take on some tips if someone out there is thinking about that. So to kind of like wrap this up, this has been a fantastic, concise, very informative webinar. What are like some key takeaways or some key points that you'd like to share with our audience about copyrights, patents, and trademarks?
Well, I really think it's important to know the differences between the different types of intellectual property, and we've touched on that here today. Well, we didn't get into trade secrets.
Oh, actually, please do. Please.
But I'll mention trade secrets briefly.
Sure.
And a trade secret is it's confidential information that is valuable because it's confidential, and it might be a customer list that a business develops over time. Maybe they've been in business and they've been selling a certain product for 10 or 10 years or 5 years, and they've identified certain companies that want to buy their product and buy it in large and profitable quantities. And the identity of those persons is going to be a trade secret to that business, because it has spent years marketing and developing its business to be able to obtain that information and know who those people are.
Right.
So but a trade secret could be a secret formula, like the formula for Coca-Cola is
yes.
considered a trade secret. It is held closely by Coca-Cola, and no one else knows it, supposedly. So it's that type of information that has economic value, and that's protected by state law. There's a Uniform Trade Secrets Act, and in most states, I believe all states in the United States, have their own version of that law. And an important thing I think to note is that if someone's going to go into business and they have a business that is dependent upon a particular set of highly confidential and valuable information, it's really important that they enter into a non-disclosure agreement with any third party before they share that information. Otherwise, if you share information without a non-disclosure agreement in place, it's free for the other person to exploit.
Excellent point.
So I think it's real important for business owners and people that are starting businesses to understand, hey, I've got to protect my valuable information, and so you want to make sure you do that with a non-disclosure agreement. And non-disclosure agreements are fairly simple agreements. Lawyers commonly draft them. I draft them all the time, and that will help you keep your secrets safe and keep your business profitable.
And how do you categorize this, Jonathan? With you have an employee, and it's let's just say they're working for a marketing firm, and this employee was like a rock star, and they accumulated a considerable client base. And then this same employee decides to go off on his or her own and launch their own marketing firm, and they have this list of clients that they've cultivated relationships with, and that's a really good rapport with, and this person takes this list of clients and converts them into their clients with their own company. Is that a conflict of interest? Is that where a non-disclosure agreement would come into play to protect their former employer?
Well, in that situation, the former employer would have been really well served by having a written agreement with the employee that says who's going to own those relationships. Is it going to be the company, or is it going to be the employee? And having that set out in writing at the beginning of that relationship would prevent this sort of thing from happening down the road. Employers and employees typically also enter into non-competition agreements that would prevent exactly the type of thing you're talking about from occurring for a limited period of time after the employee leaves employment. So, but if you get in a situation where there's no agreement in place and nothing's been set out in writing, an employer could have a strong argument that the employee has interfered with their business relationships with their customers.
Yes.
And that could form the basis for a lawsuit.
Okay. Well, and so in addition to the non-conflict agreement that you just mentioned,
Non-competition agreement?
Thank you. Not the non-competition agreement. I've learned so much today. The non-competition agreement, the trade secrets, trademarks, patents, copyrights. Generally speaking, which one would be your go-to if you're a business owner? Which one would you advise a business owner to definitely consider investing in getting, just to protect their intellectual property? Or does it just depend?
It's really going to depend on the type of business, what they're selling. But all businesses have certain basic needs. All businesses probably have a website these days, and they're going to want to protect the content of their website by copyright law.
Okay.
Now, the interesting thing about copyright law is it springs into existence as soon as pen touches paper. You don't have to do anything to own copyrights in your expression.
Interesting.
Now, on the trademark side, I talked a little bit about the prosecution versus enforcement. And so, trademarks operate similarly in that once you start using a trademark in connection with your sales of goods or services, meaning that you're using it in advertising or you're using it on your website, you're putting it on your products, you're going to develop common law rights there. But many businesses involve all different types of intellectual property. If you have confidential information, you're going to want to protect it with non-disclosure agreements before you share it with a third party. You may want to have a non-competition agreement with your employees, depending on what type of work they do for you. If a business has employees whose job it is to create things like software that are covered by copyright laws, you're probably going to want to have an agreement in place with the employee that says that the business owns that work product. So really, depending on the type of business, every type of intellectual property could be implicated, depending on what the business is doing.
Okay. It's interesting that you would bring up the example of a website, because I noticed that perusing on different websites, I do see the acronym TM, trademark, and that's stipulating that this intellectual property online is trademarked.
Actually, the TM symbol would refer just to the trademark, not to the content on the website as a whole.
Really?
Yes,
Oh.
and that means that someone's applied for a trademark application for that particular mark.
Okay.
If you see the little R with a circle around it, that means someone has obtained a federal trademark registration for that particular word or logo.
Okay.
Now, in the case of web content, that's going to be words on a page, it's going to be images, video, that's all expression that's going to be covered by copyright.
Yay! Got it.
See?
Yes.
So I think just understanding the difference between the types of IP you're dealing with can make a big difference in terms of knowing how to protect it and what you need to do, whether you need to contact a lawyer.
Absolutely. And speaking of contacting an attorney, would you mind sharing your contact information with our viewers in case they'd like to connect with you in reference to a consultation or in your services?
Not at all. I work for Lewis, Rocco, Rothgerber, Christie, LLP. We're about a 250 lawyer law firm.
Wow.
We've got offices in 10 offices in 5 states, mostly here in the Southwest. And in Las Vegas, I'm at 3993 Howard Hughes Parkway, Suite 600. Our phone number is 702-949-8200. And my email address is jfountain@lrrc.com.
Okay, excellent. Well, thank you so much, Jonathan, for being here today. I really appreciate it. I learned a whole lot, and I hope that everyone that tuned in, or those of you that you're going to tune in later on, you're in for a real treat in watching this live stream webinar talking about patents, copyrights, and trademarks, and we also got some bonus footage as well in talking about trade secrets, and you explained
Non-disclosure agreements?
Yes, non-disclosure agreements, and things that people can do to protect their intellectual property. So I'm just really pleased that you took the time out of your busy schedule to represent the firm, and also provide your expert opinion and an expert repertoire of knowledge about this particular topic. So thank you so much.
Well, thanks very much for inviting me. Very happy to be here, and hopefully I can answer some of your viewers' questions.
Oh, yes, definitely. And now we're going to transition over to having our local representative from the Small Business Administration, the SBA, Ms. Christina Stace. And she's going to share with us some resources about the SBA today. Hi there. Good to see you. Thanks for coming.
Thank you for having me.
Oh, please, yes. And it's always wonderful to have our local representative of the SBA on our broadcast, just to share the resources that you have for entrepreneurs and establishing and started businesses.
Absolutely. And this was a wonderful webinar. I've been listening to all the. It's so confusing, if you're not in,
Right. And he was very clear about everything. Yes, I learned a lot.
And he touched on a lot of things that when people call us up and ask us, you know, they want to start a business.
Mhm.
And one of the things I always want to tell them is you want to have your team, and having an attorney
Yes.
on your team, and a CPA,
Mhm.
and you know, SBA
Yes.
to really
Yes.
guide you, because you can go astray so quickly, and you know, especially sometimes even with not having partnership agreements signed, and
Right.
you know, very important stuff. So
Mhm.
save you a lot of money down the line.
Yeah, it
because,
does.
you know, people tell me heartbreaking stories, and had they got their team together, they
Right.
may have
Mhm.
had a better chance. But SBA is here to help small businesses. So SBA has been around since 1953, and we do that in a number of ways. We have a loan program. Most people think of SBA loans as all that we do, but we do more. It's a loan guarantee program. We have primarily the 7A and the 504. 7A would be working capital, inventory purchases. 504 would be more for structures, or you know, you want to buy a warehouse, you want to buy some property for your business.
Mhm.
It's a loan guarantee, so we don't do direct lending. We have lender partners,
Mhm.
and the lender partners would be where you would go to get the loan.
Right.
Depending on how much is borrowed, is how much. Usually between 50 to 85% of the loan is guaranteed to the lender. So if the loan is defaulted, they have recourse. So it's insurance to the lender, and
Sure.
gives them a little bit more peace of mind that they may, you know, they're on the fence, they're not quite sure. It's a new business,
Mhm.
what have you. So they may entertain doing it through SBA.
Yes.
SBA has fantastic resource partners, especially here in Nevada. We have the Women's Business Center, yay! They're wonderful. So if you haven't checked them out, check them out, because you have all those great resource things available. They provide counseling, they provide mentorship. Dream Builder, I just was at
Yes.
an event last week,
Mhm.
and I promoted that to a few people, because
Thank you.
they're, you know, starting out, and I said, you gotta try this program. It's really, really something wonderful. So then we also have SCORE,
Yes.
the Service Corps of Retired Executives, another
Excellent.
great resource of ours.
Mhm.
These guys are, well, women too, but they are retired folks for the most part.
Mhm.
They've been in business,
Right.
and they're giving their time and expertise back
Yes.
to people that are starting out or in business already,
Mhm.
that just need some help with how do I get started, to writing a business plan, to marketing, to all the different things that a small business owner might, you know, come across that they need. And we have the Small Business Development Center, which also
Yes.
does training and mentorship.
Excellent
and
resource. Yes.
they also can help with the loan package. So if you're interested in an SBA loan, they can help you put that loan package together before you go to the lender. So it's always better to have everything before you go to the lender, so
Sure.
you give them a better impression, because all they care about is how they're going to get their money back.
Yeah,
So you
that's
want to be able to tell them that, and so SBA provides guidance with that. So a good solid business plan is one way to
definitely.
start. SBA also has contracting assistance, so we have
Excellent.
the 8A program, which is a 9-year business development program. You have to be in business for 2 years.
Mhm.
It's not automatic. You get approved through Washington, and it was primarily designed for underserved markets. So it would be women, vets,
Mhm.
minorities, anyone that traditionally underserved in the contracting marketplace. We also have government contracting folks that go out to the bigger agencies, make sure that small business owners are getting those contracts.
Yes.
That by
Yes.
law, there's such things called set-aside contracts that they have to put in small business owners' hands.
Right.
So our folks kind of police that, if you will.
Yes.
They make sure we are mandated to do that. SBA also has disaster assistance.
That's great.
So if,
Yes.
God forbid, there's a disaster declaration, and SBA will go out with FEMA, and there we do direct loans, because that's
Okay.
the only thing where we do direct loans. Now, that would be not just for small businesses, the homeowners,
Mhm.
renters, anyone that's affected by a disaster. And I think of it as something like a gap insurance, so maybe
Oh,
you're
sure.
underinsured
Mhm.
on your property,
Right.
and they're only gonna give you X amount of dollars, but it's
Mhm.
gonna be more to repair, so that little gap there can be filled with the SBA loan, potentially, yeah.
Yeah.
So, and we provide advocacy to small businesses, so
Excellent.
we have an ombudsman in Washington,
Mhm.
we have advocacy folks, so small business owners, maybe just one guy doing his thing,
Yeah.
running his business,
Right.
but something is impacting his business
Mhm.
regulatory wise, or there's some law that's maybe being discussed that
Right.
they might impact them in a negative way or positive. SBA advocacy folks want to hear from small businesses,
they
because
do.
they do testify in front of Congress
Mhm.
on behalf of small businesses. So we do a lot of stuff. We're
Yes,
busy.
you do.
If you want to contact us, SBA.gov/NV gets you to the Nevada homepage, and we're here to help you navigate, find your way through starting your business, and to ensure the success of small business. And
Yes.
that will, really, truly, that drives the economy.
Yeah, it really
So,
does.
yeah, so.
And I'm so pleased that you're here today to share those resources. And as a former entrepreneur myself, I went online countless times
Oh.
to
I'm happy to hear that you
SBA.gov.
did that, yeah.
Oh yeah, the videos, the training, the resources.
Yeah,
It's excellent
yeah,
in
yeah.
entrepreneur development. So I
Yeah.
highly recommend to
That's
access
our
the SBA
mission.
resources. Yes.
That's our mission, so yeah, so we will help you, call our office, local number here is 702
Mhm.
388 6111,
Mhm.
and, give us a call, and, we'll help you navigate, and,
Yeah.
thank you again for having
Yeah,
me.
absolutely.
And, these webinars are fantastic. I just spoke to a lady, I think it was this morning,
Mm.
and she was asking about, for a woman business owner and starting out, and I said, oh, well, she was from Reno, and I said,
Uh-huh.
but they're located in Las Vegas. However, they do these fantastic webinars.
Oh, that's great. Thank you.
Yes,
That's
and,
awesome.
and she was really excited about it.
Oh,
and,
great.
So yeah, it's really great thing that you do.
Oh, thank you. And we couldn't do it without the support of the SBA. So thank you for definitely being the foundation that we were established
Here to
off
help.
of. Yes. And again, I'd like to thank Jonathan Fountain as well, our guest attorney, to speak so eloquently about patents, copyrights, and trademarks. And thank you again, Christina
welcome.
Stace of the SBA, for being here to share resources. And I'd like to thank everyone for tuning in today. I'm Kathleen Taylor with the Nevada Women's Business Center. And until next time, take care, and thank you so much for tuning in. Yay!